What kind of interest do you think there will be in the Unitary Patent? What kind of companies and applicants do you think will go down that route?
Well, I'm coming at it, James, very much from a litigator's perspective. So the interaction I'm having with clients is around filing strategies with an eye on future litigation. I think the best advised and the most sophisticated clients are very much looking at a combination of filing nationals, keeping some traditional bundled European patents, but also the very most sophisticated parties are looking to the Unitary Patent system and will ensure that some of their patents are either not opted out and remain in, or future patents come through as unitary patents, with a view to influencing the development of the court system and the judicial decisions. Otherwise, the fear is that decisions will be taken outside of their control, which may send the court system in the wrong direction.
So clients may want to get in there early and help shape how the system develops. What issues do you think, Michael, what issues do clients face when deciding, as they will have to do soon, if they want to have a unitary patent rather than a bundle of national patents?
I think very much along the lines of what David was saying is there's a degree of uncertainty, of course, in this thing that's coming up that will be new to everybody. From a prosecution side, not so much, but from the litigation side, of course, what will I get out of the system and out of this new court? There's this sort of juggling around, do I put what's then called the crown jewels in the system or not? That will depend largely, I think that's what's crystallizing on industries involved, who will do what. Monetization entities will have another view on that than pharma, probably, that type of thing. Issues around double patenting, what kind of basket can I actually put together, what is still allowed, what's my tools to work the new system from a bit of a national point of view. Lots of things have been discussed about. We certainly would throw our utility model into the basket if available on new stuff. So very much around that, and it's on the one hand, yes, we do need to, and we want to, now that it is coming, we want to have a leverage on forming the system and using it to make it into a properly functioning and advantageous system, and keeping a bit of security in the back end if it goes the wrong way.
Sure. One of the areas where I think there's still a lot of uncertainty is about the costs. So there's the renewal costs of the Unitary Patent and obviously the court costs as well. To what extent do you think that will affect people's strategies? You know, how much is it going to cost?
I think it will affect strategies hugely. I am hearing very consistently from clients and other contacts in industry that although they can put in all the thinking about strategy for the future and filing strategy and litigation strategy, until they have some clarity on the costs both of the application process, the opting out fee and the court system, it is simply impossible to define that strategy. It's a really serious issue. Right now we're working with a number of clients, particularly in the US, where they're going through the budgeting process into the next financial year, and also typically 2 or 3 year projections. And there's a huge gaping hole there at the moment on the costs of the Unitary Patent and the patent court system.
I guess you would agree, Michael. You'd like to see some certainty on cost. Do you have any idea, what sort of what reasonable costs might be? I mean, how many national patents is equivalent to a unitary patent, for example?
I think we've all picked up on these more or less cloudy rumors of it being somewhere between 4 and 6. Or the equivalent of 4 or 6 national designations as we now know it. Whether or not that is true, I haven't seen anything really seriously more nuts and bolts coming out of the discussions or the prep committee. It will be a or the decisive factor. I think that's all we hear, like David is saying, from clients for the new system. 4, 5, 6 probably is a sustainable level. That's what the type of clients and applicants who will choose the new system are probably running today. Some thought needs to be given to that lack of possibility to later on just drop designations. But all in all, that would probably work. But there's lots of official office considerations behind that. It is supposed to be a completely self-financing system. Court fees are talking between the UK and Germany, we are used to rather elevated court fees for serious pieces of litigation. That's not so much of a surprise. It's going to be a change for litigants from other countries. So that is a consideration.
Okay, well, thank you very much indeed.